In this video, we're going to discuss the duties of the agents and the duties of the principals, as well as the liabilities that arise under an agency relationship. So the agent has duties. They have a duty to perform, to notify the principal. They have a duty of loyalty, obedience, and accounting. We'll talk about those specifically, as well as the principal's duties, which is to compensate the agent or reimburse or indemnify, and also cooperate with the agent. We'll also talk about authority. An agent has certain authority, whether it's expressed from the principal or it's implicit or it's apparent from a third party's point of view. And then liability will arise with contracts that duties enter into on behalf of the principal and torts, the actions that might cause injuries to others. Duties owed are either set forth in the agreement or they arise by operation of law. The agent's duty to perform, or the standard of their performance, is the agent must use reasonable diligence and skill in performing the work. If we have an agent who is a minor, we already know that minors can be agents, but they have to use reasonable diligence and skill in performing that work. They have to be able to do it. So what is the degree of skill or care required? Well, what's expected of a reasonable person in the same circumstances. Now, if we're talking about somebody who has special skills, like an accountant or a doctor or a lawyer, they have to use they're expected to use those special skills in their performance. An agent must notify the principals of all matters that come to his or her attention concerning the subject matter of the agency. And I will say, under agency law, notice to the agent is actually considered notice to the principal. For example, Annette, the manager of a grocery store, is notified of a spill of milk in one of the aisles. If she fails to take steps to clean up that spill and a customer is injured, is the store going to be liable? Yes, the store is going to be liable. Notification to Annette as the agent for the principal was good enough. But Annette will eventually have to notify the principal of this as well. Duty of loyalty. An agent has a duty of loyalty to their principal, meaning they act solely for the benefit of the principal. They cannot act in their own self-interest or an interest of a third party. We call this a fiduciary duty. And if the agent breaches this fiduciary duty, it's an automatic termination of the agency relationship. So, for example, falling under the duty of loyalty, confidentiality. Aaron is an agent of ABC Insurance. ABC Insurance has a customer list that is confidential, and Aaron has a copy of it through his agency relationship. Question 1, can Aaron disclose the contents during his agency? No. It's confidential. Can he disclose the contents after the agency terminates? And still the answer is no. It was confidential at the time of the agency and it's going to remain confidential. If Aaron discloses, it's going to be considered a breach of the fiduciary duty. Agent makes authorized purchase order from Mega Corporation. As a token of appreciation, Mega provides 2 tickets to a sporting event for the agent. And the question is, does the gift of tickets need to be disclosed to the principal? And the answer is yes. This would fall under notification, but it's also a breach of loyalty. Can't act in own interest. It might be in the agent's own interest to go to that sporting event, but it's not for the agent to have those tickets. Need to be disclosed to the principal. An agent has a duty of obedience. When acting on behalf of the principal, the agent must follow all lawful and clearly stated instructions of the principal. There are 2 examples of this: emergency situations. There might be a situation, somebody's injured, and the agent needs to act. And if the principal cannot be consulted, well, then the agent can act. Basically, they're kind of protecting the principal in that instance. If they don't act in a time-sensitive situation, the consequences could be worse. They also can act if the principal stands to suffer a loss. Then the agent can deviate from the instructions. Again, got to act for the benefit of the principal. An agent also has a duty of accounting. The agent must keep and make available to the principal an account of all property and funds received and paid out on behalf of the principal. This includes gifts from third parties and prohibits commingling of personal and agent accounts. So for example, Marta is a salesperson for roadway supplies. Knife River Construction gives Marta a new tablet as a gift for prompt deliveries of roadways paving. Who owns the tablet? Not Marta. Roadway owns the tablet. Whose account should the tablet be accounted for? That's going to be Roadways. The principal also has duties to the agent. They can be expressed in the agreement or they can be implied by law. Compensation. The principal has a duty to pay the agent for services rendered. It could be agreed upon amount, or if there's no amount that's agreed upon, the principal is going to owe the agent the customary compensation for the agent's services. The other duty that the principal has is a duty to reimburse and indemnify the agent. So if agent disperses funds at the request of the principal or pays for necessary expenses in the course of performing the duties, the principal must reimburse. Reimburse and indemnification are kind of the same, but they're slightly different. The principal must indemnify or compensate an agent for liabilities incurred because of authorized acts, as well as for losses suffered by the agent or others because of the principal's failure to perform his duties. This has kind of got a legal component to it. So if an agent orders supplies on the principal's behalf and the agent is ultimately held liable for that payment, the principal must indemnify the agent for the liability. And lastly, the principal has a duty to cooperate. A principal has to cooperate with the agent and assist the agent in performing his or her duties that they're supposed to do on behalf of the principal. The principal must do nothing to prevent that performance. So for example, Peggy creates an agency with Don, which allows Don to sell Peggy's products exclusively in one area or territory. Can Peggy be held liable to Don if she permits another agent to sell in that territory? The answer is yes, for lost sales, because he has an exclusive for that territory and the principal isn't cooperating with their agreement. And I'm going to note it is important that a principal does not owe the agent any fiduciary duties. The fiduciary duties are only owed by the agent. The principal doesn't have to act for the benefit of the agent. It's the other way around. The liability of a principal to third parties to whom an agent enters into contracts with, depends on whether the agent has the authority to enter into legally binding contracts on behalf of the principal. An agent may perform only those acts that have been authorized by the principal or a court. If the agent exceeds the authority, he can become personally liable unless the unauthorized act was reasonably assumed by a third party to be within that agent's powers. There are types of authority. The authority of an agent can be expressed, implied, or apparent. Expressed authority is, well, in orally or in writing. These are the terms. This is the authority I'm going to give you. It can be implied by the actual position that the agent has, and it could be apparent. This is what a third party reasonably but mistakenly believes. Let's talk about expressed authority. Tricky question. Zoe orally asks Parker to sell a ranch that Zoe owns. Parker finds a buyer, Gloria, and signs a sales contract on behalf of Zoe to sell the ranch. And the question, well, we have our agent, who's Parker, principal is Zoe, and our third party is Gloria. Can Gloria enforce the contract? Based on authority, does Parker have authority to make this contract? Yes, and it's expressed authority. But ultimately, can Gloria enforce the contract? And I'm going to say no, because statute of frauds has to be in writing. Any interest in land has to be in writing. Zoe orally asks Parker to sell the ranch. That agreement needs to be in writing. So ultimately, Gloria can't enforce it, but for a different reason. But Zoe gave expressed authority here for Parker to sell the ranch. Now, if it was in writing, then we would have an expressed authority and Gloria would be able to enforce the contract. Implied authority is the authority an agent, the agent reasonably assumes he or she has that relates to the expressed authority granted by the principal. So it's implied, or it's part as a custom, it's inferred from the position. So let's talk about the example. King owns several hardware stores and hires Smith to manage one of the stores. King tells Smith that Smith is in charge of the personnel at the store, but King has the exclusive power to purchase inventory. What is the express authority here? King tells Smith that Smith is in charge of personnel. That's the expressed authority that Smith has, as a manager of the store. But King also creates a limitation. Smith can't buy inventory. So if Smith decides to buy inventory, then any transaction Smith enters into is beyond the authority granted, and the principal wouldn't be responsible to that third party. But implied authority. What other contracts could a manager in this position have? How about selling merchandise? This is a hardware store. If Smith has a customer is looking for a hammer, can Smith make that deal? Yes, that would be implied authority. It comes with the position. Implied authority is what the agent reasonably assumes. Apparent authority comes from a third party's reasonable but mistaken belief that the agent has actual authority to enter into a contract. And this kind of authority can bind our principal as well. But the key here is the third party's reasonable belief. Remember our Marcus example? Remember Marcus in the valet parking? Even though he wasn't an agent, third parties assumed that he was. So the court created an agency by estoppel, and therefore his authority was apparent. Another example, Kevin, the assistant manager of a sporting goods store, offered customers a 25% reduction on the prices of all merchandise in his department store during an end of season sale, despite the fact that authority to change prices was limited to the store managers. So the question is, does the store have to honor the reduced prices? So Kevin's an assistant manager, offered 25% reduction despite lacking actual authority to change the prices. But customers would be reasonable in assuming that Kevin had authority to reduce the price. So here the store is bound by the doctrine of apparent authority. So the result, the store must honor the reduced prices because third parties reasonably believed Kevin had the authority to make changes. All right, let's talk about the liability components for contracts. Generally, a principal is responsible to third parties for all agreements made by the agent on behalf of the principal if the agent acted within their scope of authority. If they don't act within the scope of their authority, then the principal isn't going to be liable. We're first going to talk about contract liability, but we also are going to talk about tort liability. Contract liability is agreements made within the scope of the authority. They'll bind the principal. When we get to torts, those wrongful acts committed by the agent during authorized duties will create a principal liability. So let's distinguish these two, and we're going to start with contracts. In determining liability for a contract formed by an agent, it's going to depend on whether or not the principal was disclosed in some way to the third party. So we have disclosed principal, we have partially disclosed principal, and we have an undisclosed principal. So our disclosed principal is the obvious. The identity of the principal is known to the third party at the time the contract's made by the agent. So the agent says, I'm so-and-so Smith, and I work for ABC Insurance Company. Well, we've just disclosed that there's a principal involved, the insurance company, and Smith is the agent. Partially disclosed principal, the identity is not known by the third party, the principal's identity, but a third party knows that the agent is acting for a principal at the time of the contract. So I'm Joe Smith, and I'm here on behalf of my employer, who's an insurance company. We don't know who specifically the principal is, but we know that Joe is working on behalf of an insurance company or a principal. Then we have the undisclosed principal. The identity of the principal is totally unknown by the third party at the time of the contract, and the third party has no knowledge that the agency is acting in any agency capacity. So Joe Smith is there to sell insurance, and they don't disclose one way or the other that there is a principal. So if the agent is acting within the scope of their authority and they contract with a third party, this is how the liability rules will unfold. If we have a disclosed principal, the principal is completely liable, agent is not, if something goes bad with that contract. If we have a partially disclosed principal, both the principal and the agent would be held or could be held liable to the third party. And if we have an undisclosed principal, agents may be liable, but the principal is going to be liable unless the principal was expressly excluded as a party to the contract. So there's nowhere written anywhere or stated anywhere that a principal is involved. The contract is a negotiable instrument, which doesn't indicate that the agent is acting in a representative capacity. An example of a negotiated instrument is a promissory note or a check. And then third, performance of the agent is personal to the contract. So let's say the agent is a musician and the contract requires the agent to give the concert. The principal isn't even involved or has nothing to do with that. So the principal is going to be liable unless we're dealing with one of those three types of contracts. And I will note, if the agent is acting outside the scope of their authority and the principal doesn't ratify, then the agent is liable to the third party, unless the third party knew agent was acting outside the scope of the authority. So we do have an exception to that rule where an agent acting outside the scope of their authority, and then we don't have a principal who ratifies the contract arrangement, the agent will be liable unless the third party knows that agent's acting outside the scope. Tort liability. Generally, a principal is liable for the torts of the agent if they are committed at the direction of the principal or while the agent is performing unauthorized duties during the ordinary course of the agency. A tort liability arises when the conduct of the agent creates a loss for the third party. Types of torts in this area: negligence. Somebody, the slip and fall in the aisle at a grocery store caused by product that was spilled and it was left there for hours, there's no sign. Or purposeful conduct, like an intentional tort. An example of an intentional tort is fraudulent misrepresentation. If an agent makes a fraudulent statement to induce a third party to enter into a contract, and that is being done within the scope of their authority, then the principal is going to be responsible. The principal is going to be responsible or liable for a tort caused by the agent under the doctrine of respondeat superior. It's Latin, means let the master stand. The doctrine imposes vicarious or indirect liability on a principal without regard to personal fault of the principal for the torts committed by an agent in the scope of the agency. So basically the principal is they didn't cause the conduct, but their agent did, and the law will impose liability on that principal. First, though, the agent must be liable in some way. They have to be found negligent or that they've made that false representation. So before we make a principal liable, it's not automatic. The agent has to be found liable for the tort before that liability will pass to the principal. And the agent must be operating within the scope of their employment. So principal's liability depends upon whether the agent's tort was committed within the scope of employment. For example, if Dan, the employee of a delivery firm, negligently runs a red light and injures Kate, who's a pedestrian, the owner of the truck is liable for Kate's injury. Now, the principal might argue we didn't, it's not within the scope of the agency that people drive negligently. That's not really going to fly. If Dan is an employee of a delivery firm and he's operating the truck while he's out delivering, happens to run a red light, that's going to fall on Dan to be found liable, and then that liability transferring to the principal. So the issue is whether a particular activity that the employee agent is engaged in is within the scope of their employment. They do not care if that was an authorized act or not. Some examples of scope of employment. Mike's having a cup of coffee at work. He accidentally spills hot coffee on a client during a meeting and the client suffers burns. Within the scope of agency, yes, principal is going to be liable here. He's during work meeting and burns a client. Example 2. After work, Mike stops at Starbucks to grab a cup of coffee. Mike happens to see a client sitting at another table, goes over to say hello. Mike, having a bad day with his coffee, accidentally spills his hot coffee on the client. Client is burned. Is Mike liable for the injuries here? Yes. Is the principal going to be? No. This is happening outside the scope of employment. Example 3. After a business meeting, client expresses concern with being able to tell the cab driver where his next destination is. Mike, bringing his hot coffee with him, escorts a client out of the building. Despite employer policy that employees cannot leave the building without permission during working hours, he does this anyway. While hailing a taxi cab for the client, Mike spills his coffee on the client. Client suffers burns. Is this action within the scope of the agency, which then would result in the principal being liable? And the answer is yes. His actions are related to work. Yes, there is this employee policy that they cannot leave the building, but so he steps outside the bounds of his authority, right? But he's still within the scope of employment. Is Mike furthering the interest of the principal by helping the client? Yes. But what if Mike says, oh, I can't leave the building. Sorry, can't help you out. What's the client going to think? So in this instance, we're still going to have scope of employment, and the principal will be liable for any injuries suffered by that client. And lastly, intentional torts. The principal is liable only if the tort was foreseeable and within the scope of the agency. I used the example earlier about making fraudulent misrepresentation statements in creating a contract. Another example of intentional torts is actually physically hurting somebody. If we have a bouncer at a bar who pushes an unruly patron in an attempt to get the patron off the premises and that person is injured, is the principal liable? Is it within the scope of employment? Is physical force foreseeable? Is that part of the bouncer's duties? We might have some liability here. A museum guard, a guard at a museum uses a taser to get an unruly patron to listen to his command to exit the premises. Well, if the principal issued the taser, there's a suggestion that they say, hey, use it. A taser might be excessive force in a museum context, so questionable here, but if the principal is aware and it's foreseeable, we might have some liability on the principal in this instance. So for intentional torts, courts examine whether the harmful act was a foreseeable risk of the type of work of the agent was hired to perform, not just whether it occurred during working hours.